Hi, for everyone joining us in honor of World Whistleblower Day, this panel will cover important developments in international whistleblower law, as well as the existing mechanisms through which international whistleblowers can report wrongdoing. My name is Maraya Best, and I'm an attorney at the law firm of Condon and Colapinto LLP. For this discussion, I am joined by Mark Worth and Kelsey Condon. Unfortunately, Mark Worth is only able to call in at this time, so you won't see him on your screen. Mark Worth is an investigative journalist, public interest activist, author, and one of the world's foremost experts on whistleblower policy. Amongst his many accomplishments, Mark has held significant leadership positions in several international and regional organizations dedicated to whistleblower rights. He is the executive director of the European Center for Whistleblower Rights, the co-founder of Southeast Europe Coalition on Whistleblower Protection, and a board member of the Platform to Protect Whistleblowers in Africa, as well as the founder of the Whistleblower Program at Transparency International. Kelsey Condon is an attorney at the law firm of Cohn and Colapinto LLP in Washington, D.C. She specializes in representing whistleblowers under the Foreign Corrupt Practices Act and the Dodd-Frank Act, with a special interest in natural resources, wildlife, and environmental protection. While most of Kelsey's cases remain strictly confidential, her accomplishments include working with the Danske Bank whistleblower Howard Wilkinson on the largest international money laundering case in world history. Kelsey, Mark, thank you both for being here today. This last year, particularly since a whistleblower came forward with concerns about the Trump administration's dispersal of aid to Ukraine, it seems like the news has been full of stories of whistleblowers around the world shining light on corruption. With this surge in favorable press for whistleblowers, it also appears that many nations have begun re-examining how they treat these vital public servants. In fact, this year the EU passed its first directive exclusively on whistleblowers. Mark, with your expertise in Europe, can you begin by telling me a little bit about this new whistleblower directive and what it means for European whistleblowers?
Sure, Maraya, and thank you for having me on the panel today. And I do apologize that the video doesn't seem to be working. The directive, which was passed, a directive is a piece of legislation that applies to all EU member countries. So there's 27 now since the UK left. Is an amazing step forward. It follows. You mentioned there have been a lot of whistleblower cases, massive whistleblower cases in recent years. The LuxLeaks case, the tax evasion case in Luxembourg, the Panama Papers case seem to be the two main cases that led the European lawmakers to pass the directive finally after many, many years of pressure from activists, from our groups and journalists and lawyers around the world. It's a very strong piece of legislation. It was improved significantly in the deliberation process in the Parliament and the European Commission by activists who pushed for example, a very strong right to be able to report misconduct to the public directly. It has strong provisions on disclosure channels to regulators. It has strong protection measures for retaliation, and it also has penalties for things like retaliating against a whistleblower or violating a whistleblower's confidentiality. So it's quite strong on paper. The concern, of course, is it going to work in practice? Europe, most countries in Europe, and I mean not just the EU, but the greater Europe, over 50 countries, does not have a good record of protecting whistleblowers and ruling in their favor in courts or other venues. So we're going to be pushing very strong for these laws to work at the national level, but we don't automatically encourage someone to use a whistleblower law. We encourage them to report things anonymously, report things to us, so we become their representative, their advocate, so they can be buffered from retaliation. But it is an enormous step forward legally. Also, in terms of the message it sends to citizens that the governments will now be at least trying to stick up for their rights. So it's a major, major victory. And I want to thank all the activists who joined to make it possible.
Oh, absolutely. And for those persons joining us who aren't totally familiar with the EU system, can you explain what a directive means and how that will translate to national law?
Sure. Quite simply, a directive is a mandatory piece of legislation in the sense that it requires all the member countries, all 27 members of the European Union, essentially most of Western Europe, to pass a piece of national legislation that complies with the directive. Now they can go beyond it. So we will be pushing, we are pushing with Condon, Calapinto, and with the National Whistleblower Center and my organizations to add whistleblower rewards to the national legislation that will be passed in response to the directive. The directive does not include rewards, but that doesn't stop the countries from including rewards into their own national laws, and that's what we'll be doing, actually starting right now.
Great. And do currently any European nations have laws in place that include reward provisions?
Hungary has a very slight provision. Ukraine, which is not in the EU, does have a whistleblower reward provision. These have not. Lithuania, which passed a law 2 or 3 years ago, has a whistleblower provision, but in the first year of Lithuania's laws, in an article that we wrote for Frontline Whistleblower News, none of the 5 people who applied for awards in Lithuania were given the funds. So as far as I know, nobody in Europe has ever gotten a whistleblower reward. There have been some rewards given to people in South Korea, in the Republic of Korea, and also in Malaysia. It's picking up some steam, I know, in Canada and in the UK. But as far as I know, no whistleblower has ever received a reward. Of course, they've received compensation for damages, back wages, and such, but never an actual reward, no.
And can you talk me through a little bit as to why reward provisions are so crucial and what a strong reward program should look like?
Well, I think that the work that your firm has done and other firms in the United States and increasingly around the world have done to use the reward provisions in the American laws to draw people out. We think that the rewards serve in a way as a form of unemployment insurance, if you want to look at it that way. That might not be the most elegant way to describe it, but we know the retaliation is almost automatic if the person's name becomes released. So we think it provides financial security to people. The risk that they take, especially on a large case, can be career ending for people, or maybe they're blacklisted in their industry. So we think it provides that extra incentive for people to come forward, a sense of security, so they can start anew after the whistleblower case is over. We've seen the number of reports increase dramatically after reward provisions have been added to American laws and also in South Korea, as I mentioned. And this is really found money. I mean, it's not money that comes from public budgets. It's money that comes from the fines that the guilty parties have to pay off the top to the governments in the particular countries. So it doesn't cost the taxpayers any money. It provides a thank you to the whistleblower. It provides him or her with financial security for their next career move or their life. So it does give that extra incentive for people to come forward, and the extra security that their career won't come to an end without anything to fall back on.
Yeah, absolutely. I think you put it very succinctly and very well. Just a couple more logistical questions on, whistleblowing in the EU. Will this new directive mean that European whistleblowers can no longer report to US regulators or use US whistleblower laws?
Absolutely not. I think there's nothing in it that would preclude that. I know several people who have multiple cases in multiple jurisdictions right now, so I think that it would not prevent that. There may be some issues in terms of evidentiary issues and confidentiality that would have to be worked out down the road, but it would not prevent someone from also utilizing the American laws, no.
All right, great. Well, thank you so much, Mark, for that overview. Turning more internationally to Kelsey, my first question for you is, what do you think the strongest international whistleblower law is currently?
Definitely the Foreign Corrupt Practices Act, or the FCPA.
And can you tell me a little bit more about what that is?
Sure. So the FCPA is a U.S. law that prohibits the payment of bribes to foreign government officials in order to obtain or retain a business advantage, such as winning a government contract or avoiding taxes. The FCPA also requires that publicly traded companies make and keep records that accurately reflect the company's transactions in order to ensure that no bribes are paid. Moreover, whistleblowers who report violations of the FCPA are awarded a percentage of the proceeds collected through a successful enforcement action.
Okay, and what entities are covered by the FCPA?
In general, the FCPA applies to companies that trade on US or international stock exchanges, as well as companies that trade American depository receipts on US exchange and subsidiaries of publicly traded companies, even if that subsidiary isn't publicly traded. US citizens or residents or any private US company with its primary place of business in the US may also be prosecuted under the FCPA.
Got you. So given that, it sounds like this law touches both on securities concerns as well as criminal conduct as we talk about bribery. Who, in your professional opinion, should whistleblowers make reports to as they discover misconduct?
So while both the SEC and DOJ have concurrent jurisdiction to enforce the FCPA, meaning that they both can investigate and fine companies for violations of law, to maintain confidentiality and anonymity provided to the whistleblowers under the FCPA, whistleblowers should report just to the SEC Office of the Whistleblower and not to the DOJ.
Okay, so then coming back to my original question, why do you think the FCPA is the best tool for international whistleblowers?
So the FCPA allows whistleblowers to remain confidential and anonymous while helping to stop international corruption, and they're protected by very strong anti-corruption provisions. The SEC is required to protect the identity of whistleblowers who report through their whistleblower program. And if a whistleblower submits information through an attorney, their filing will be anonymous initially, even to the SEC. And once there is an enforcement action that the whistleblower helped with, that whistleblower must be awarded between 10 and 30% of that sanction. And they may also be eligible for awards from sanctions of other government agencies like the DOJ on similar prosecutions.
Okay, and then my final question on this law is, does it matter where a whistleblower is from in making an FCPA report?
No, it does not. A whistleblower can be from anywhere in the world. It doesn't matter if you're a US citizen or if you live in the United States. For example, the case that you mentioned at the top, Howard Wilkinson, and many other cases that we have, they're not US citizens and they don't live in the United States.
Okay, great. Thank you very much for that brief overview. I have 4 final questions for our panelists today, although Kelsey, I expect you will probably field this first one. What do you think makes the FCPA unique in the realm of whistleblower laws?
So the FCPA, unlike any other law in the world, is it's much more comprehensive. It provides a strong confidentiality and retaliation protections while also providing very large monetary awards for assisting law enforcement. And it also has very far reach because the law allows the US government to sanction companies and individuals even if they're not US based. It gives the US international jurisdiction.
Great. And Mark, do you have any other laws that you would like to mention here that you think are great mechanisms through which international whistleblowers can report wrongdoing?
Well, I mean, there are many, many laws in the United States, but in terms of laws that are not in the United States, we have a lot of really good laws on paper. The Australian law is quite good. Some new laws passed in Europe, in Sweden, in Ireland. Are quite good on paper. There have been some decent laws actually passed in the Middle East, in Africa. I mentioned South Korea. I think is a very good law in practice. But it's really kind of unfortunate because most of the really, really good laws that have been passed on paper have not really been tested in practice. We don't know if they're going to work or not. They're quite new. The governments are having trouble setting up their agencies. They don't know how to handle a case. I've sat with officials, anti-corruption officials all over the world, and they stare at me in the face and they say, we don't know how this works. There's such a fear. There's such a reluctance. There's such a resistance to actually granting the whistleblower status, finding in his or her favor, granting the protection and the compensation. It's almost like the official or the judge, him or herself, feels like he or she is sticking their neck out with the whistleblower, and they themselves might be subject to retaliation. So we have a lot of coaching and training to do in order to make the officials and the judges comfortable with granting the retaliation and giving the person the whistleblower status.
Well, it sounds like we've got a ways to go. My last question to you both is, what do you see as the future of international whistleblowing, and do you have any final message you would like to share with international whistleblowers? Either one of you can jump in on that.
Sure. So, I mean, I see kind of the future for international whistleblowing being in maybe like conflict minerals or natural resources, two areas that are particularly prone to corruption risks that undermine good governance. Companies have certain obligations to disclose information relating to these areas to the SEC, and the CFTC, which also has a strong whistleblower program, can investigate manipulation of market prices. Because many of these companies operate outside of the United States, international whistleblowers will play an important role in stopping corruption in those areas.
Absolutely. And Mark, do you have any final words of wisdom you would like to share on this topic?
Well, we're very excited because with Condon and Colapinto and the National Whistleblower Center, our groups, mainly Whistleblowing International, will be starting a new website on international whistleblowing, making people aware. People have very little idea that the American laws that Kelsey went through have an international reach. The number of international reports to the IRS and the SEC has gone up in recent years, as you know. So we want to make people all over the world aware that they very well might be eligible for whistleblower status and monetary rewards under the American laws. So we're going to be spending the next several years building up the international outreach to citizens, to the media, to labor unions, to anti-corruption activists, not just making them aware about new laws being passed internationally, but the strength and reach and power of the American law. So that's our emphasis in the years going forward. And we're very excited about it. I think that once people know that the American laws are so strong and that the enforcement behind them are becoming greater, that people will be more likely to report corruption because they think that it will actually make a difference and that some enforcement and prosecutions will result.
Great. Well, thank you both so much for joining me. As Mark said, it's a very exciting time. And, you know, I'm glad to be able to share the experience of these experienced panelists with all of you out there. Thank you.
Thank you both.
Thank you very much.